My name is Patrick Gorman, and I am the managing attorney and partner at the Bradford Barthel Reading office. For those of you who don't know, Reading is a city in the state of California, and we do have an office up here. So if any cases are ever venue that you need assistance on, or if you need to run by any doctors up here who you've never heard of, anywhere from Marysville north to the Oregon border and then west to Eureka and Crescent City, do not hesitate to contact me. My information's right there. Also, you can always contact me via email, first initial, last name at bradfordbarthel.com. I'm very excited to present this information, this webinar to you. It's new information, new litigation. Although the labor code changed 1/1/2013, this area of litigation really hasn't begun to emerge until recently. Why are we here? Essentially, there are delineations in the labor code that separate medical, legal, invoicing, and billing practices from lien claimants. Judge Levy, the presiding judge in San Diego, provided training to all of the workers' compensation judges last October, and he's thought to be the expert on this area of the labor code by the other judges, probably because he gave the training. Also, Judge Petty wrote an article recently on this topic. It's on Work Comp Central, essentially outlining, it's more of just a summary of the applicable labor code sections and regs. There are some former defense attorneys and applicants' attorneys who are going around to the standard, lien claimants, MedLegal LLC, Gemini, and some of the QMEs, mostly chiropractors and dentists in Southern California, and they've been doing training on this topic to try to drive litigation, so here we are. Again, here's my contact information, and I'll provide it at the end of the slideshow. So the body of law we're going to be discussing today are Labor Code Section 4060. That's what defines what med legal expenses are. If something's not a med legal expense, then it's not applicable. They have to file a standard lien or petition for costs under other portions of the labor code. And we'll go into what med legal is versus what is not med legal. Labor Code Section 4061 covers self-procured medical legal reports. This would be a consultation obtained by an injured worker on a lien basis in a denied case, things of that nature. And finally, Labor Code Section 4622, that's the big one. That's the main reason we are having this webinar today, and the main reason you're going to want to know this information. That provides the requirement that you respond in a certain manner, in a certain time, and if not, it provides mandated penalties that are not discretionary to the med legal provider. Then we're going to cover 8 CCR 10451.1. This covers additional time frames, jurisdiction of the Workers' Compensation Appeals Board over matters of medical necessity and other issues. Also, it provides a section for reimbursement of attorney's costs and sanctions for bad faith actions and tactics. Essentially, when we're looking at this body of law, we need to also recognize that the other side, the lien claimants and their attorneys and hearing reps, have a completely different interpretation of what these sections cover and what the definitions mean than what we have. So we'll cover that as well. So this is an increasing area of litigation. Again, as I said, it's emerging from around October 2016 to the extent Judge Levy had to provide training statewide to all workers' compensation judges, letting them know that this area is going to be emerging and increasing. There's statutory penalties for failure to timely respond to medical legal invoices. Again, we'll go into what medical legal invoices are, but there's penalties for either not timely responding or even timely responding in the inappropriate manner. There's no lien filing fees. They don't have to pay money to get into court or to allow the board to have jurisdiction. They are not a lien claimant. It's viewed as lien claimant type activity, but we need to delineate the two now, because we're not going to deal with these issues the same way we're going to deal with the standard lien claimant, where we're going to try to file a DOR or get them dismissed for failure to appear or not filing fees or for a faulty declaration. They don't have to issue the 4903 declaration or anything like that in order for the board to continue to have jurisdiction over these issues. Any medical legal provider has standing to file a petition. Again, they do not need to file a lien. They only need to file a petition, and we'll get into that more. There's a potential for award of costs and attorney's fees pursuant to the reg I cited before, and again, we'll go into that because I believe that's going to be one of the main driving forces for litigation here. You're going to have, I don't know why an applicant's attorney wouldn't want to get involved and represent his Cairo buddy who, sends cases his way and who he sends clients to, and try to recover $400 an hour for filing a petition and dragging you into court. So the most important question when we're dealing with this area of litigation is whether or not the invoice you are looking at qualifies under the statutory scheme. In order for it to qualify under the statutory scheme, it has to be a med legal expense. What's a med legal expense? Well, fortunately, the Labor Code provides a definition, unlike other areas of law where they just give an ambiguous term and allow the judges to discretionarily interpret what those mean. So med legal expense, it's right there. It's a cost or expense incurred by or on behalf of any party, which may include x-rays, lab fees, blah, blah, blah. The main thing you need to know is it's diagnostic. It is a med legal evaluation or interpretation, and it has to be bold and underlined for the purposes of proving or disproving a contested claim. Those are the key words. It has to be for the purposes of proving or disproving a contested claim. So now we need to ask ourselves, what does that mean? What is a contested claim? You're going to find when you're dealing with MedLegal, LLC, Gemini, some of these Kairos or whoever, they're going to tell you that a contested claim is a contested issue. That's not true. Contested claim exists when the employer has actual and constructive knowledge that an employee is claiming entitlement to a benefit arising out of a claimed industrial injury. And one of the following conditions exists. So in lay terms, the injured worker has to be claiming a benefit, and the benefit claim has to be denied. The benefit claimed is deemed admitted because of basically you didn't deny it within 90 days, right? Or you fail to respond to a demand for payment of benefits after expiration of any time period fixed by statute. This is your 14-day delay notice, your 90-day denial notice, your statutory timeframes to initiate, delay, or terminate permanent disability or temporary disability. Those would be the applicable timeframes here. So we have a very clear definition. We have lien claimants, or I guess in this case, med legal claimants, saying that, oh, well, this involves a contested issue, or trying to, really just vague up the terms, but we have clear statutory definitions in the Labor Code stating exactly what med legal expenses are, what a contested claim is, and what conditions need to be present for them to get into court under the statutory scheme. If they can't get into court under this statutory scheme, they need to file a lien. So the next section, so that was all Labor Code section 4620. That gives you your definitions of who qualifies as a med legal provider and what conditions need to exist for the cost to be justified as a med legal expense. There's also self-procured med legal expenses under a separate section of the Labor Code section 4621. Labor Code section 4621 provides for reimbursement of medical legal expenses to an employee or the dependents that are reasonably, actually, and necessarily incurred. In these cases, I'm trying to find a clean example here because most of the time, the employee, the injured worker, or the dependents aren't going to actually self-procure medical treatment and incur the actual costs. Costs are going to be deferred. There's sections of the Labor Code that state that medical treatment can't be sought against an injured worker, and essentially their remedy is to go into court and try to recover against the insurance carrier. My thoughts on this are that you have lien-based treaters who will come in and perform these initial consultation reports, and they'll then bill it out as a med legal expense. If you don't pay it timely or send them an EOR, they may request penalties, attorney's fees, blah, blah, blah. But there's a caveat to that. No employer is liable for any medical legal evaluation performed within the first 60 days of any claim being filed, absent an affirmative denial of that claim. So you have a case where your injured worker goes to the chiro that his buddy went to, or that his attorney, who's not technically his attorney right now, tells him to go to, and they issue an initial consultation report and bill you $1,200 for it. You do nothing because it's a delayed claim or denied claim, and a year later you get a petition for penalties, sanctions, etc. Those would qualify under this case if it's a denied claim and the evaluation happened after the first 60 days or after the affirmative denial. What about defective medical legal reports? Do you have to worry about sending an EOR or incurring penalties, interest, and attorney's fees if you get a report that does not constitute substantial medical evidence, or that is untimely per the regs, or that was improperly procured, such as, I had a case where an injured worker was sent to a QME, a chiro QME. He wasn't a QME though. He had just acted as a QME usually, and his attorney attempted to obtain a Gonzalez-type report rebutting our panel QME that issued a take-nothing report, essentially. And we know that you can't just go and self-procure your own med legal. But if it was a PTP, that would be different. So things that don't qualify as admissible under the labor code or that are defective, they don't qualify. The cost of medical evaluations, diagnostic tests, interpreters that are, and keep in mind, they have to be incidental to a medical report. They do not constitute medical legal expenses unless the report is capable of proving or disproving a disputed medical fact essential to an adjudication of the employee's claim for benefits. What does that mean? Well, there's a en banc decision pertaining to the admissibility and payment of fees for vocational rehabilitation experts, the Costa decision from 2007. And in that case, the psychologist, who was also a voc expert, wanted to recover on their several $1,000 invoice for issuing a report to rebut the permanent disability rating schedule. And what the board determined in that case was that the doctor and voc expert in that case was entitled to recovery, but it was because their report was admissible and would have been beneficial or useful. So I think those are the terms this is relating to. It does not constitute a med legal expense if it's on an issue that's not a contested claim, or if it's not admissible, or if it's not useful. In other words, they're talking about apples and the contested claim is oranges, and the evidence essentially doesn't prove the contested matter. Only admissible medical legal evidence is subject to the statutory scheme. So you have cases where you've removed a PQME and all of their reports are inadmissible for all purposes. Those would not qualify under the statutory scheme. You have untimely reports. Those would likely not qualify as med legal expenses so long as you've timely objected to the report, in other words, before it issued. So we have to be aware of self-procured medical legal reports pertaining to primary treating physician recommendations. There's a case out there, Simmons v. State of California Department of Mental Health, where a primary treating physician mentioned that somebody had a hip problem. Their hip was bothering them. Alluded to it being industrial. It was a back and knee injury. Fast forward 6 months, the doctor requests a total hip. And the insurance company sent it to UR. UR denied it. IMR upheld. The judge found that the PTP's report was admissible for medical legal purposes because the defendant did not object pursuant to Labor Code Section 4062. So the main part is the main reason of putting this in here is you need to make sure that if you're objecting to the admissibility of a report, that your objection was within accord of the Labor Code or the regs. Okay, so Labor Code Section 4622, that's really the meat and potatoes here. This is what is going to dictate what you need to do, when you need to do it, and what happens if you don't. So it covers all medical legal expenses for which an employer is liable. Those are all medical legal expenses that are not self-procured or self-procured pursuant to Labor Code Section 4621. We just covered that. So Keep in mind, we always need to make sure it's a med legal expense, and if it's self-procured, we are liable. Labor Code Section 4622 also mandates your response. You have to respond by an EOR, even if the expenses are denied. I get this a lot, where we have a petition or a DOR with the petition filed, and the med legal claimant or lien claimant who's alleging they're a med legal claimant wants penalties. And the client is always saying, well, I objected to the invoice. You have to respond by way of EOR. And we'll get into this more. Judge Levy has outlined some belief or preference that the EOR has to be perfect. In other words, there's no incidental defects to the EOR, and I disagree. I mean, I respectfully disagree. We looked at this and saw this in Dubon 1 versus 2, and there's no requirement that the EOR meet every single perfection possible. You can't find an illusory defect in order to invalidate the EOR, but we'll get into that. That's more of a hypothetical issue. There's strict time frames for you, the defendant, and for med legal providers to comply with. And if you don't comply with these time frames, there's dramatic remedies. The med legal provider either has their med legal invoice deemed paid in full, or the defendant incurs penalties, interest, and potentially attorney's fees. What penalties? Well, the Labor Code mandates, this is not discretionary, a 10% penalty and 7% for the untimely response. And what we'll get into later is if you don't timely respond by way of an EOR, you no longer have the right to contest the amount invoiced. So you can't argue reasonableness and necessity if you do not timely respond. You owe a 10% penalty on the total invoice amount. If this is delayed or you don't receive the petition for 4 years, well, that's 7% interest on top of the total amount plus the 10% penalty for every year thereafter. What are the mandatory timelines? These are important. The Labor Code provides that upon receipt by the employer or the insurance company of all reports and documents required by the administrative director incident to the services, so in other words, all of the documents you would need in order to perform an EOR and bill review, you have 60 days. So it's a generous timeline in the form of a lot of timelines we have that are 14 or 30. You have 60 days to issue payment in full, partial payment accompanied by an EOR that contests reasonableness and necessity, or by denial. And the Labor Code mandates that your denial still must be in the form of an EOR. So what you need is you need a $0 EOR or an EOR denying that it's a non-legal expense, things of that nature. But either way, the denial letter is not going to preserve the time frame. If you contest the amount paid, you must request the provider, the med legal claimant, must request a second review within 90 days. If they fail to do so, they cannot recover anything. Their bill is deemed paid. So if you issue partial payment with an EOR, they have 90 days to invoke essentially the IBR process. And if they fail to do so, then their bill is deemed satisfied. And they also have to request a second review pursuant to Labor Code Section 4603.3. Also in Labor Code Section 4622, it just re-enumerates the IBR process. Now remember, the contesting the amount, the response in 90 days, contesting the amount paid, so this is where there's a partial payment, arguing that their invoice is an inappropriate application of the fee schedule, that would then invoke the IBR process. It only pertains to disputes of the invoice that are contesting the amount billed under the fee schedule. If the employer denies all or a portion of the bill for reasons other than a dispute over fee schedule, so reasonable necessity, you have some of these lien claimant, these Kairos in SoCal, I've heard rumors. I actually practice in the Bay Area and then up here in Redding. I haven't ever practiced in LA, but I hear horror stories all the time about chiropractors ordering, 6 MRIs and you have an ankle sprain. Maybe that's hyperbole, but either way, you can contest reasonableness as necessary where fee schedule hasn't even come into play. So if you deny all or a portion of the bill for reasons other than fee schedule, the provider must object to the denial within 90 days. And if they don't, then there's no liability. The amount denied is deemed paid or not recoverable. And we'll go more into requirements if there's a timely objection. If the provider either timely objects to the ELR on the basis of fee schedule, or if there's a partial payment or total denial ELR and they object on those grounds, there's certain obligations on your part once you receive that objection. Okay, so I just crammed a bunch of information out there, and it's all floating around, and I think the best way to really apply this and understand what we're talking about is to go through some scenarios. Okay, so scenario one. We have an injured worker, injured Joe. 1 week after being terminated for failure to show up at work, he submits to his former employer a DWC-1 claim form alleging a cumulative trauma injury to his neck, back, and hips due to repetitive work. You issue a delay notice pending further investigation and confirmation of whether or not there's evidence of injury before he was terminated. You receive a notice of representation 1 day later from Mr. Kaw Esquire. He sends with that notice of rep a report issued by Dr. Hack. And for some reason, Dr. Hack always treats Mr. Kaw Esquire's clients. The report is titled Initial Consultation Report. There's an invoice for $6,500, some lab studies, and 6 MRI reports. You know, I never see lab studies. I don't know why they don't want to rule out rheumatoid issues and things like that, but maybe that's it. The 6 MRI reports would be there, though. You do not refer the invoice to bill review. 65 days later, you receive a petition filed by a new attorney, former defense attorney Esquire, demanding payment of the $6,500 in full, 10% penalties and interest thereon, and attorney's fees in the amount of $400 per hour for your bad faith actions and tactics. And we're going to get into that later. That's towards the end of the presentation. Is this a med legal expense pursuant to Labor Code Section 4620 or 4621? No. Labor Code Section 4620 defines med legal expenses as costs or expense incurred on or behalf of any party, which include x-rays, blah, 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 for the purposes of proving or disproving a contested claim. This is not a contested claim. You're within your denial period, your 90-day investigatory period. So it's not a contested claim. There's been no denial of benefits. There's been no statutory expiration of a time in which you have to provide benefits. And there's actually been no demand for benefits either. You have to provide medical treatment until you affirmatively deny for up to $10,000. And in this fact pattern, you haven't exhausted that $10,000 either. Also, Labor Code Section 4621 provides reimbursement of medical legal expenses to an employee or the dependents that are reasonably, actually, and necessarily incurred. But this happened within the first 60 days of the claim being filed, and there's no affirmative denial of the claim. So this guy, the doc and former defense attorney Esquire, they don't even get you into court. Now, practically, is that your only argument? No, I recommend that you still send in the $0 ELR. But this is your fallback argument. If you have to bring an attorney in because a petition is filed and you're noticed to appear at a board for a hearing on that petition, it'd be nice if you had more than just the argument that this doesn't qualify as a med legal expense. If you have a $0 EOR that wasn't timely responded to or other timeframes weren't met by the lien claimant, then there's another basis for them to not even take you into court. Okay, second scenario. Dr. Quack is a PQME at a separate denied case, so you have an affirmative denial that you have involving Sore Jane. Sore Jane somehow requested a Cairo panel upon receipt of the denial letter and selected Dr. Quack from that panel only weeks before retaining Mr. Kaw Esquire as her attorney. We've all seen this happen. Dr. Quack evaluated Ms. Jane on March 1st, 2017, and issues a report on April 1st, 2017, finding Ms. Jane TPD 100% for her bilateral carpal tunnel syndrome. So we have an issue maybe with the report. We've got a report that's 31 days after the evaluation. You receive an invoice and report from Dr. Quack on April 5th, 2017 with an invoice for $13,000, accompanied by bilateral EMG studies and 6 MRIs. You send a letter to Dr. Quack objecting to his reporting and advising him you are not paying for his garbage report and take no further action. This was the old way of doing things, and I'd be surprised if some of you don't have objection letters floating out there that have been issued in the last 4.5 years, and we can't really unring that bell. But going forward, I don't know if that letter is really gonna suffice. It's not EOR. 65 days later, you receive a petition filed by Mr. Former Defense Attorney Esquire demanding payment of the $13,000, 10% penalties and interest, and of course his attorney's fees for your bad faith actions and tactics. Is this a med legal expense pursuant to Labor Code Section 4620 and 4621? Maybe. We have a late report. It's 1 day late. Maybe it's 1 day late. It does a +5 apply. Did you object? Did you issue a letter objecting to the timeliness of the report and indicating that you're not going to pay for it and that you're going to replace the PQME? Well, on one hand, the report may not be admissible and it may not qualify as a med legal expense, but it's really going to boil down to when you objected, if you objected, and when the report issued. Are we at 30 days or are we at 31 days? It's not very clear cut. Next question, if the report does constitute med legal expenses, and that is capable of proving compensability, remember this is a 4060 evaluation, it's not a 4061 evaluation, you're not disputing PD, you're disputing whether or not the injury is a compensable injury, meaning it is occupational. If so, did you abide by the mandatory timelines outlined in Labor Code Section 4622? Did you respond valid, in a valid manner? No, you issued an objection letter. So we'll get into the substantiality and things like that, but again, you know, it has to be on the issue disputed, and while his findings of her being 100% TPD for bilateral carpal tunnel syndrome constitutes substantial evidence, if I were Dr. Quack's attorney, I would argue that the contested issue or contested claim was admissibility. There was no permanent disability dispute at that time. So no, if the employer denies all or portion of the bill for reasons other than a dispute over fee schedule, the denial must still be in the form of an EOR. So in the last scenario, like I said, you're always best served by issuing a timely $0 EOR. One more scenario, and then we'll move forward. Similar facts. Dr. Quack is a PQME in a separate denied case you have with Angry Frank. Angry Frank also requested a panel and then retained Mr. Caw Esquire as his attorney. He's evaluated on April 15th, 2017, report issued 30 days after the evaluation date, so it's timely, and finds Mr. Frank to be totally temporarily disabled for a sprained thumb. He's received an invoice from Dr. Quack, April 25th, 2017, for $12,500. On June 20th, less than 60 days later, you send an EOR advising you're not paying for his garbage report. It's late. Well, may not have been late. It may be in 31 days. It may be 30 days, but either way, you're objecting to reasonableness and necessity within your 60 days. And then 65 days later, you receive a petition filed by former defense attorney Esquire demanding penalties. What happens in this scenario? Does it constitute a medical legal expense? Well, I mean, again, it's kind of a flimsy report on the issue of TTD, but you have a denied case and he finds injury. So let's assume that it is a compensable, an admissible report. Did you comply with the time frame set forth? Yes, you responded within 60 days with a $0 EOR denying all of the bill. Do you owe him any payment? No, because he didn't object to your denial. He did not object to your $0 EOR. He hired former DA Esquire to come and try to drag you into court. So his invoice is satisfied. Okay, so looking back to scenario 2, the outcome repercussions for failure to abide by the mandatory timeline. This is the case where you timely responded with an objection letter, but not a $0 EOR. So the Labor Code mandates that within 60 days after receipt of each separate written billing and report, and if the payment is not made within 60 days, that portion of the bill then unreasonably unpaid shall be increased by 10%, together with interest thereon at the rate of 7% per year, retroactive from the date of receipt of the bill and report by the employer. What does that mean? Okay, well, we see the word unreasonably, and that tends to indicate that the judge might have some discretion, but you'll see under this statutory scheme, they do not. So again, 60 days is your time frame. You must respond by EOR. Otherwise, you're going to get hit with 10% plus 7% interest, and as we discuss later, with attorney's fees. And we'll also see in a moment here that you will not have the ability to contest the amount invoiced if you do not timely respond in the appropriate manner. Seems rather harsh, or if the report is outrageous. Well, does the late report constitute a med legal expense? If the report was not objected to before received, as we discussed, and constitutes substantial evidence with regards to the purpose of the evaluation, compensability of injury, again, you must respond by way of objection to an EOR, and I can't reiterate that enough. I know I've said it about 7 different ways, but again, keep in mind, if you get an invoice, whether it's med legal or not, it's always best to respond by EOR within 60 days. In scenario 2, there would be a mandatory penalty of 10% plus 7% interest. It would be due in full, because the only means to contest the reasonableness of an invoice is also by way of EOR. So if you did not timely respond with an EOR, then you no longer get to contest the reasonableness of the invoice. So in this scenario, you're stuck with the argument that Dr. Quack's report does not constitute substantial medical evidence and is inadmissible. That's a lot of eggs in one basket. And depending on what board you're at and what judge you're in front of, it would be very difficult to get a sympathetic response from the judge or the trier of fact and law. What about attorneys and fees and costs? Again, we're going to get into that in just a moment, because that's really going to be the driving force of this litigation. So, most importantly, the failure to comply with any of the timelines constitutes a waiver of any objection other than the amount invoiced pursuant to the official fee schedule. So if you don't timely respond with an EOR, then you cannot contest the amount billed unless it's a misapplication of fee schedule. And again, fee schedule for med legal evaluations, QME reports, it's a dollar amount per hour. You're not going to be able to contest the fact that the doctor billed 17 hours to review medical reports. What if the provider then objects to your denial? So you filed a timely denial, the $0 EOR denying payment, and the provider timely objects. That is their obligation. We know that if they don't object, then you owe them nothing further if there's a partial payment and nothing if there's a $0 payment. So if the provider objects to the denial within 90 days, the employer / insurance company must then file a petition and declaration of readiness to proceed within 60 days of the objection. So again, this is passing the burden, passing the responsibility. You have a timely EOR. They now have a timely objection within the 90 days from receipt of your EOR. And now you have to file a specific petition that's defined in the regs and a DOR within 60 days. And if you don't, I don't know if that precludes or waives your objection on medical reasonableness or medical necessity and reasonableness, but it doesn't have the same repercussions as an EOR, but there's another catch-all portion of this reg that says if you fail to comply with any of the timelines, then essentially you have to pay the penalty. So we'll get into that. All right, so now we're in the regs, and this is what gives the board jurisdiction over these disputes. You'll know that the Workers' Compensation Appeals Board does not have jurisdiction over IBR and disputes that have timely been responded to with an EOR and that are either being processed under IBR or weren't timely responded to. So this carve-out provides the remedies and jurisdictional hooks for these types of disputes. So again, you have a timely EOR. You then have a timely objection to your EOR from the provider. State that you shall concurrently file a petition for determination of non-IBR medical legal dispute and a declaration of readiness to proceed. So this is required if you've denied all or a portion of the provider's medical legal billing for reasons other than IBR fee schedule. And the defendant has objected to, the provider has objected to the partial or full denial within 90 days. So this is only if you met the time frame, the med legal provider met the time frame, and we're not disputing fee schedule. Fee schedule, again, is subject to IBR, and the board still does not have jurisdiction over those disputes. Okay, so if the issue is fee schedule and they respond in 90 days, then you must go through the IBR process. And if IBR awards payment, the payment must be made within 20 days of service of the order to pay. This is the same as your regular IBR process. And again, the Workers' Compensation Appeals Board has no jurisdiction over IBR. So if the dispute is over fee schedule, that's not what we're talking about. Non-IBR med legal disputes. The board has jurisdiction to resolve all non-IBR med legal disputes and mandates the duties on you and on the med legal provider. Non-IBR med legal disputes include, and this is enumerated in the reg, any threshold issues such as coverage, employment, affirmative defenses, or jurisdiction. So if your argument is, I had no coverage, so I'm not liable, or they weren't my employee, then the board has jurisdiction over that. Whether or not the medical legal expense was for the purposes of proving or disproving a contested claim. So again, that initial threshold question, you're going to have to file a petition, or the other side will file a petition, and you're going to have to litigate whether or not their services constituted a med legal expense. Reasonableness and necessity. Now again, if you don't have a timely EOR, then you cannot contest reasonableness or necessity of the invoice. You can only contest fee schedule. An assertion that you have waived any objection because of failure to timely comply. Again, that's your 60-day time frame, and then additional 60 days after receipt of their 90-day objection to your $0 EOR or partial payment. An assertion that the med legal provider waived any claim because they failed to timely comply. Or an assertion that an interpreter does not meet the criteria set forth in the labor code, so they're not a certified interpreter if they're required to be certified, or they're not a qualified interpreter, things of that nature. Or an assertion that the interpreter was not reasonably necessary. Good luck with that one. I've never seen a judge not disallow or find that an interpreter is not necessary. IBR only pertains to disputes regarding the amount payable under the official fee schedule. So don't confuse being in an IBR situation when you're not. If you're objecting to time billed and not the rate they billed at, then you're not at the fee schedule. You're at the reasonableness and necessity, and you're going to have to issue the partial payment EOR, and then if there's a timely objection in 90 days, you're going to have to file the petition and EOR within 60 days therefrom. All right, so earlier I mentioned that a med legal provider does not have to file a lien, and this is why we're delineating this from standard lien handling, because they do not have to file a lien. A medical legal provider is not required to file a lien to claim costs. They simply can file the petition for determination of non-IBR medical legal disputes, or they can go through IBR. But again, that's a separate issue. You don't have to worry about the attorney's fees and penalties once you get to IBR, so long as you pay within 20 days from receiving the IBR determination if it says you have to pay an additional amount. Okay, additionally, this is one thing to be concerned about. We always, as a matter of practice, have deferred liens until the case in chief is resolved, and then you file for a lien conference after, a month or two of trying to resolve the lien, and then sometimes you get a continuance. Sometimes this is years after the med legal evaluation or after the records were subpoenaed. And the judge has the discretion to defer hearing the issue. But keep in mind there's 7% per annum interest. On the flip side, I mentioned the cost of decision earlier. If the issue is whether or not the evidence is admissible, you need to keep that in mind if you're going to see an R case and you haven't resolved the dispute. You're going to have to, or want to, put some language in there indicating the evidence was not admissible for some valid reason. It can't be illusory, but you want to protect yourself from incurring the penalties and the 7% interest. This is the case I was speaking about earlier, where over the last 3.5 years, we've been just sending objection letters and not $0 EORs. The WCAB does not have to defer the issue. They can hear it at that time they're separate issues. Again, if you want to defer it, that gives you the argument that there must be a finding that the report is admissible and the matter is not ready to proceed. So you have options to either put the matter off or expedite it, depending on how it benefits you the best. It's a strategic decision for you and your attorney to make. Clarification of who must file the petitions and DORs when the filings are due. So we just went over a whole new set of time frames, and those time frames are invoked once you receive that 90-day objection to your partial or $0 payment enumerated in your EOR. So you are required to file a petition and a declaration of readiness to proceed if it says defendant, but the med legal provider responds to your denial of all or a portion by way of an EOR. So again, this is non-IBR. There's a partial payment because a doctor billed 17 hours to review 300 pages of records, and you issue partial payment for his review, and you send it by way of an EOR within 60 days of receipt of the invoice. They then object to your partial payment. You must file a petition and a DOR. So you're going to have to get an attorney involved at this point. It has to be filed within 60 days of receiving the objection from the medical legal provider. On the other hand, the provider may file a petition for determination of non-IBR medical legal dispute if you breach any duty. So any of these time frames, so you missed the time frame to respond by EOR, they can file the petition. You missed the time frame to file the petition and DOR yourself, they can then file a petition. What about former defense attorney Esquire's request for costs and attorney's fees? Where did he get that from? And again, I mentioned a couple of times, this is going to be a driving force for litigation. If the Workers' Compensation Appeals Board determines that as a result of bad faith actions or tactics, the defendant failed to comply with the requirements and timelines outlined in Labor Code Section 4622 and then these IBR provisions, defendant shall be liable for reasonable attorney's fees and costs and for sanctions under 5813, HCCR 10561. Monetary sanctions shall not be less than $500. So this is where you really get into the lawyer-driven type litigation, where it's what does this mean? What invokes your obligations to pay attorney's fees for not issuing a timely EOR? And one interpretation, the opposing side's interpretation, is that any untimely EOR constitutes bad faith actions, just as a matter of fact or per se. And I disagree. There needs to be bad faith actions. The board needs to make a determination that there's bad faith actions or tactics. And this labor code section references HCCR 10561, which then goes to filing a petition that's incorrect, that's verified, or making false representations, litigating for the purposes of harassment, things of that nature. So I disagree with Mr. Former Defense Attorney and with Judge Levy and Petty. There's no case law on this issue. Again, the most important thing is you want to make sure that you abide by these timelines so that you're never making this argument in court where you didn't timely do something and now you're arguing that you didn't act in bad faith. That's always a bad position to be in. And the cost of litigating is most likely going to be more than the amount that the attorney driving this litigation is going to request. So it puts you in a position where you have to make a business decision at that point. What constitutes bad faith actions or tactics? Well, it further defines that bad faith actions or tactics may include, but are not limited to, failing to pay an uncontested portion. So if you are arguing after you didn't, if you issued a partial EOR or you didn't issue an EOR and you issued partial payment or no payment, and there's no contest over the amount billed, so you know the evaluation was 3 hours and you decided you only wanted to pay for 1, or the doctor's deposition was 2 hours and you decided you were only going to pay 1 because you didn't like what he said during the second hour, well, that's bad faith. Failing to make a good faith effort to comply with the applicable timelines. So again, the other side's interpretation of this reg, this section of the reg, is that any failure to timely comply constitutes bad faith. Well, I think that their position is contradicted by the reg itself, where it says that you failed to make a good faith effort to comply with the timelines. contesting liability based on a dispute over injury or injury to a particular body part. This, of course, would be if there was an untimely EOR and you're arguing that, well, I didn't have to submit an EOR because the shoulder was denied. You still have to issue an EOR if there's a disputed injury or disputed body part, especially because it would absolutely qualify as a medical expense at that point because you have a contested claim. And then, of course, as I said above, those actions outlined in 8 CCR 10561, those are the knowingly falsifying a petition that's verified, things like that. Cost, sanctions, and attorney's fees shall be in addition to the penalties enumerated in 4622. So this is in excess and in addition to. However, there's also bad faith actions and tactics enumerated by a provider. And essentially, if they file a petition, DOR, and they try to drag you into court, claiming you failed to comply with the timelines, and they are wrong, you may be entitled to recovery for your attorney's fees. Again, it's very ripe for litigation. You have the provider's position that any violation of these time frames is bad faith per se, and they get costs, sanctions, etc. Keep in mind, a specific finding of bad faith is necessary for costs and attorney's fees, so you have to go to trial. There has to be a specific finding. They have to show that you acted in bad faith. There's a similar standard enumerated in the other sanctions reg, 8 CCR 10561, and that shows, essentially what bad faith is. That gives you a very clear definition of bad faith. Does any failure to pay an uncontested amount make a good faith effort to comply with timelines or contesting liability due to compensability of a specific body part constitute bad faith actions or tactics? So what if you have a partial EOR timely served and you say, we're not paying you for these records because they pertain to the shoulder and the shoulder is denied? Well, you have a legal dispute because you have a contested claim. And again, that's not a basis for disputing. So they then timely object in 90 days. You go to court because you have to file a petition and DOR in 60 days. It seems to me that if your basis for not paying for the medical legal services are because they pertain to a body part or injury that is denied, then that would constitute bad faith actions or tactics. So keep in mind, always the purpose for these evaluations and these expenses is to prove or disprove a claim. So if your basis for an objection or denial and timely issuance of an EOR is that it's a denied body part, then that's counterintuitive to the law. All right, so practice tips, we'll go through these quick. We're running short on time. When in doubt, always respond to an invoice and report in the form of an EOR within 60 days of receipt. So you need an invoice and a report. But again, if you receive even just an invoice, always respond in the form of an EOR within 60 days. Even if it's a $0 EOR, always respond within 60 days by way of EOR. Order of handling. So you're always going to ask yourself whether you respond in the form of EOR or not, or in determining whether you respond in the form of an EOR or not. You always want to ask yourself, is it a med legal expense? If so, you have to respond within 60 days from the date of receipt of the invoice and report in the form of an EOR. They then have 90 days to object or request a second review if it involves fee schedule. If they fail to respond in 90 days, it's deemed paid. You're not liable. If they object to a partial or total denial within 90 days, you have to file that petition we discussed and a DOR. You're going to need to involve counsel early on. If you miss this time frame, then your attorney is going to only be able to do the best they can to clean up and pick up the pieces. Failure to abide, you have 10% penalty with interest. Waive any objection other than the schedule. So no longer can you object under the reasonableness and necessity, or hey doc, you spent 13 hours reviewing 700 pages, or whatever the dispute may be. They may file a petition if you breach any duty, and their attorney will likely argue bad faith, want sanctions, and they're going to try to shake you down for about $1,300. So again, I understand that was a lot to cram into 1 hour. How are we doing on time? 8 minutes. Great. We have some questions. Quickly though, I did want to cover some supplemental information. It'll take me about 2 minutes. It's not in the slideshow. I encourage you to go and review my blog on our website, bradfordbarthel.com. You can also find me on LinkedIn, and my article is published there. A lot of you do not deal with this issue much because most of the claims, about 80% of them or more, are in the population centers of California. But there is a separate access standard for rural MPNs, which are defined as places where there is a service shortage. And I just want you to keep in mind that if you have an MPN in a rural area, it may not be invalid. You only need a reasonable amount of doctors within 1 hour or 30 miles of the injured worker's address who are willing to take on the case. So the access standard for LA, the Bay Area, Sacramento, Fresno, and those places where you need to have multiple doctors in any given specialty within 15 miles of the injured worker's address is not applicable. A lot of the applicants' attorneys in rural areas, my area included, they just go into court assuming that every NPN is invalid and try to steer these guys towards doctors who don't know what they're doing. Again, that is not the access standard. Read my article, and if you have any questions, again, email me, text me, or call me. And we're going to go ahead and cover some questions here. Okay, so the first question is, can a primary treating physician bill MedLegal for a drug denial where the PTP submits purported proof the drug should have been approved? Well, it would boil down to whether or not the request for drugs was diagnostic. I've had a case where a doctor wanted somebody to take some nitroglycerin for a couple weeks to determine whether or not there was in fact a heart issue or if it was a pulmonary issue. In that case, it may have qualified as a med legal cost. But again, did the doctor dispense? Were there any costs incurred, or are we talking about the report? I think that the first question that you always need to evaluate is whether or not this is a med legal expense. And the med legal expense must be for the purpose of proving or disproving a contested claim. This is not for denials of treatment. Okay. The next, I hope that answers your question, Michael. If you have any other follow-ups on that, email me or give me a call. The provider sends the initial bill and report, which a $0 EOR is issued. Good job. That right there is the biggest hurdle. The provider then sends a bill each month, hoping to get it paid. Does a timely EOR need to be issued for each subsequent bill? No. Once you issue that $0 EOR, they have 90 days to respond by way of objection. This is enumerated in the labor code. If they do not, their bill is deemed paid. And if they continue to send bills and things of that nature, they may be subject to your costs and attorney's fees. I would argue that their continued attempt to procure payment of this expense they're not entitled to might constitute bad faith. You might want to talk to whichever attorney is going to be appearing at the regional board where this is occurring so that they can give you a read on the judges. Some judges might throw them out because we're not harmed at this point. We haven't paid anything at this point, and we're incurring fees just because they're annoying us. But again, if you have to keep processing these bills or they're trying to use one of these gotcha tactics, that might be subject to litigation. I like to compare this to utilization review, and where you have a timely non-certification, and then the doctor finds out there's a non-certification and they just issue a second RFA without noting any material and change of circumstances. Again, your UR denial in that case is good for 12 months. Now, the labor code doesn't state that your denial of this bill, your $0 EOR, is good for 12 months, but it does mandate another action on behalf of the provider. So I would say, no, you don't need to keep responding that it's deemed paid, but you might want to take care of it affirmatively or proactively by going to the board instead of letting them file 12, 13, 15 invoices, and then you have to go and litigate and they have some argument about waiver or something like that. All right, I'm seeing MedLegal billings from the PTP for reports written responding to IMR findings. Are they medical legal or not? That's a good question. I do not believe that an IMR non-certification substantiates this becoming a contested claim. The board, that would be a really shaky jurisdictional issue for the board. Again, they don't have a means to go in after the fact and insert their opinions with regards to IMR. Again, you have to have that contested claim. You have to meet the criteria, and it has to be a denial of benefits presumably that the applicant was entitled to, a delay of benefits, presumably that the injured worker was entitled to, or a presumption of admissibility. I think in this case, you have the argument that it's not med legal. That is interesting because, Gonzalez does provide the injured worker with the ability to obtain med legal opinions from their primary treating physician. I would respond to all of them with a $0 EOR, setting forth your grounds for objection. That way the board has no jurisdiction to hear it one way or the other. Again, contact me, Jill Marie, if you want to talk about that further. I can direct you to an attorney at that regional board who can help you out with determining where it might go or how it might go with the judges in that area. Okay, and then the next question, I objected to a PQME prior to receiving the report and requested a panel. I still received the bill. What reason can I use to deny the bill via EOR? Well, first, would your EOR be within 60 days? If so, you can issue a $0 EOR stating that the report was untimely, it's inadmissible, doesn't constitute substantial medical evidence. Essentially what you would have put in your objection letter, you're going to put in your explanation of review. If you haven't timely responded by way of EOR, if it's been beyond the 60 days, I think you have a valid argument that the report does not constitute a med legal cost because it was untimely. It cannot be introduced to prove or disprove the contested claim, and you timely objected, i.e. you objected before you received the report. So I think you're in pretty good shape on that one. Again, when in doubt, always respond with a $0 EOR. You can just issue an outright denial. You do have to state a basis for your denial. You can't just say, I deny it, but I think the timeliness is a basis for denying payment. Does a copy service bill constitute a med legal bill? It can. It can. I'm actually dealing with a consolidation effort against a copy service on this very issue. A lot of applicants' attorneys just outright subpoena records, whether the claim is admitted, TDs being paid, and medical is being provided, or if it's denied. I think it has to be a contested claim. That's what the labor code states. It's not a med legal expense. If it's not a med legal expense, it's either applicant's attorney's cost pursuant to Labor Code Section 5811, or it's lien-based provision of services. So unless it's a contested claim, unless you have a denied claim, then it's not a med legal expense. If there's a contested portion of the claim, let's say you have a denial of one body part and an admission of a naughty body part, then you might have to respond by way of EOR because the medical records pertaining to the denied portion might fall under the contested claims section. Now this provider, I assume it's Med Legal LLC, they're going to argue that there's a contested issue, and they try to use the word issue and claim as a mutual equivalent or synonymous, and they are not. The Labor Code says it has to be a contested claim, and then it defines what a contested claim is. So it gets a little grayer there. Again, there's no body of case law addressing this. When in doubt, respond with an EOR. So if you still are within your 60 days, Alicia, then respond with an EOR. If you're outside of the 60 days, then you're probably going to need to litigate this, and you're probably going to need to litigate whether or not it is a med legal cost. If you guys have any questions, please email me. You can call me. You can text me. I'm always available 7 days a week. Thank you very much for your time. Again, please review my article on the rural access MPNs so you don't have to provide treatment with doctors who don't know what they're doing out in the sticks. All right, everybody have a wonderful afternoon. Enjoy your lunch, and I'm going to put Tammy back on for additional information.